The heading for hearing, serial number 22, the State of Bihar versus Rajendra Ram, for the appellant Sri Ujjwal Kumar Sinha.
May I please, Your Lordship? My Lords, yesterday the matter was heard. The single bench order is at the challenge, in which, my Lords, the order of punishment has been set aside, mainly on the ground of insufficiency of evidence, saying that oral evidence ought to have been laid, which has not been laid, and therefore it was held that the conclusion drawn was not correct. My Lords, I have placed before your Lordships the steps which had been taken for initiation of a departmental proceeding. At the outset, I may submit, my Lord, that the punishment is almost minor in nature. Censure and stoppage of 2
charge
increments.
is remaining unauthorized absent.
Beg pardon, Lords?
Charge is that he remained absent.
Unauthorized absence, that has not been proved. Lords, only the charge number, there were 8 charges. Out of 8 charges, my Lords, only charge number 5, 6 and 8 had been proved. Unauthorized absence was charge number 1, which was found not proved. Had it been proved, then perhaps major penalty could have been awarded. But that was not proved.
Which are the charges proved?
Beg pardon, Lords?
Which are the charges proved?
Charges proved are, my Lords, charge number 5, 6 and 8. And charge number 2 and 4 partly proved. Charge number 1, 3 and 7 not proved.
2 and 4.
2 and 4 partly proved, and charge number 1, 3 and 7 not proved. My Lords, after a preliminary inquiry, my Lords, the
On what ground
charge sheet was...
on what ground single judge has set aside the penalty order?
Majorly on the ground that the evidences which has been laid for the purposes of proving the charge were not sufficient. Oral evidence ought to have been laid, which was not laid, and therefore...
No, which are those documents cited in support of proved charges?
The documents were all, my Lords, official documents which were part of the file and records, because the charge is...
We'll take example,
my Lords.
charge number 2, which is partly proved.
My Lords.
Read the charge number that has been extracted by the land single judge.
May I read, my Lords, charge number 5, perhaps that is the main charge?
No,
which has been found
we'll
proved.
go by one.
My
Charge
Lords.
number 2 is partly proved.
My Lords, I'll place the charge sheet, my Lords. Charge sheet is annexure, my Lords, 4. Now,
No, you don't want to read the extracted charge memo.
charge memo.
Charge memo has been extracted by learned single judge.
In Hindi, my Lords, that is very short, but in Hindi,
sir, it is
the charge
page
sheet
3
gives
of the
detail.
order.
Beg pardon, Lords?
Page 3 of the order, please.
Yes, I have seen it, but that is pretty short.
That means
Charge is in great detail.
That means
my
the
Lords,
learned single judge has diluted
reduced
the charge.
reduced the charge into
diluted
only
the
4
charge.
lines, whereas, my Lord, the charge is reading quite detailed, my Lords. Therefore, at page 44 of the writ application.
every charge my lord will find that आरोप प्रमाणित होता है, उसी में आरोप पत्र में ही लिखा हुआ आरोप प्रमाण हर चार्ज में.
No, no,
So
this
therefore,
was
there is no question to
All right,
initiate.
read charge number 2.
my lord, श्री राम की प्रतिनियुक्ति प्रभारी दंडाधिकारी भभुआ के रूप में श्री भूपेश गुप्ता कॉलेज भभुआ में इंटरमीडिएट परीक्षा के तहत अनुमंडल पदाधिकारी भभुआ ने अपने पत्रांक सच 24/393 द्वारा की. यह आदेश उन्हें हस्तगत भी कराया गया, परंतु ये कार्य पर नहीं गए. इस पर अनुमंडल पदाधिकारी दैट इज SDO भभुआ ने अपने पत्र दिनांक 28/3/93 द्वारा स्पष्टीकरण की मांग की, पर आज तक इन्होंने वांछित स्पष्टीकरण समर्पित नहीं किया. इस प्रकार इन पर उच्चाधिकारियों के आदेशों का अवहेलना के दृष्टांत भी प्रथम दृष्टया आरोप प्रमाणित होता है.
One second. No, he did not discharge the duties in the post of magistrate. Who has given that show cause notice?
Sub-divisional officer.
Has he been examined? Would please ask him.
Whether this sub-divisional officer was examined, SDO Bhabua,
my lord,
he had issued show cause.
Ask him to show the evidence of other.
my lords, those were all admitted documents, my lords, on
No,
record.
whether the SDO
No,
Bhabua
my lords,
was
no oral
examined.
evidence. Oral evidence was not taken. My lords, that is what. my
Then
lords-
that is a sufficient, because there are serious allegations against the respondent,
my lords,
which is required to be examined with reference to the documentary read with the oral evidence.
my lords, my submission is, my lords, whether oral evidence is an essential.
Yes, sir. In terms of the apex court decision, in the case of UCO Bank versus SC Giriotra reported in 1995.
My lords, in my humble submission, my lords, I have got 2021 judgment, my lords.
Please
of the,
pass on that. 2021.
Three judges, my lords, I have given.
That
the
oral
list.
evidence is not required.
Yes, my lords, oral evidence is not necessary, and in my lords, various departmental proceedings where the charges are based on my lords documents,
All right, show me that
On the file.
oral evidence is not warranted.
essential. My lords, may I place para 22?
Read.
The power of judicial review in the matter of disciplinary inquiries exercised by the departmental and appellate authorities, the three judges bench, my lords, authorities discharged by the constitutional courts
Is it
under.
Dalbir Singh?
Beg pardon?
Dalbir Singh.
No, this is, my
Respondent.
lord, State Bank of India versus Ajay Kumar Srivastava.
All
Three
right.
judges bench, my lords, a very detailed
All right,
judgment, my lords, on this
Read
point.
the relevant portion that oral evidence is not warranted.
No, no. It says that sufficiency or insufficiency of evidence in a departmental proceeding cannot become a
Therefore, you that will not
Is-
assist in respect of oral evidence.
in judicial review under Article 226, my lords, sufficiency of evidence. If there are some evidence of any nature, then that is sufficient.
No, it has to be proved by corroborative evidence. No, corroborative evidence means
The evidence
oral,
act,
oral
my
evidence.
lords, my lords, there are two judgments, three judgments, my lords, on this point, my lords, where it says that oral evidence is not essential. What is required that
Sir,
there has
read that portion. Oral evidence is not essential.
my lords, may I place para 22, 23, 24, which are the relevant paragraphs, my lords. May I read it?
What happened to the books? No, why you people not given in advance?
Already given the list of the books.
Huh?
My lords, on this point, my lords, I will place several other judgments as well.
The show cause notice is not. That has been or no allocation of work has been modified. That is the reason. When disputed facts are there, oral evidence is required.
My lords, there is no.
Government advocate.
Sir, page 51,
My lords,
the reply by the respondent shows that the order of the SDO was modified and he was part of the patrolling team visiting all the colleges. Kandika 2, page 51.
Master,
my lords,
he's citing
may I-
2021. You are bringing some old books.
Please
What
go,
is this?
Please go through para 2 of the page, internal page 2, page 51.
my lords, may I read the finding of the inquiry officer?
प्लीज पुनः इस खंडिका में लगाए गए आरोप के संबंध में सो कहना है कि दंडाधिकारी के रूप में नियुक्त किया गया था, उस आदेश को 3/4/93 द्वारा परिवर्तित कर दिया गया और मेरी प्रतिनियुक्ति उड़नदस्ता दंडाधिकारी के रूप में सभी परीक्षा केंद्रों में की गई, जिसका अनुपालन मैंने ईमानदारी से किया।
जी। इसके अनुपालन में
In that case, the SDO was required to be examined, cross-examined by the respondent.
Therefore, it was partly proved, not fully proved.
All right.
How
Now,
it
how-
has been
how
for the,
part-
even for assuming that partly proved with reference to what evidence?
My lords,
Because he has been assigned subsequently different duties.
the inquiry report will be essential to be read, my lords, for that.
Uh-huh.
How the inquiry officer has, because the inquiry officer was
No,
appointed.
we are not reappreciating evidence here.
No,
We
no.
are only seeing whether in support of charge number 2, whether oral evidence has been adduced or not. That's all.
Oral evidence, no, कोई oral evidence with
Which
respect
is the
to none of
paragraph? This 2021.
My lords,
Ajay Kumar Srivatsav.
my lords, SBI versus Ajay Kumar Srivastava, para 22, 23 and 24. May I
Para
place it?
23.
22, 23 and 24 and 25.
Shows the relevant portion that
Yes.
the oral evidence is not warranted.
What is warranted, my lords? The scope, my lords, has been dealt with, my lords. May I place it? The power of judicial review in the matters of disciplinary inquiries. My lords have got it. Exercised by the departmental and appellate
No,
authorities.
we are not doubting.
My lords,
We are not doubting on this.
no, it has dealt with it by constitutional courts under Article 226 and Article 32 of the Constitution of India is circumscribed by limits of correcting errors of law or procedural errors leading to manifest injustice or violation of principles of natural justice, and it is not akin to adjudication of the case on merits as an appellate authority which has been earlier examined by this court in the state of such and such and such, wherein it has been held as under. The disciplinary authority is the sole judge of the facts. Where appeal is presented, the appellate authority has coextensive power to reappreciate the evidence or the nature of punishment. In a disciplinary inquiry, the strict proof of legal evidence and finding on that evidence are not relevant. That is what, my lords, I was trying to submit.
There is no oral
Adequacy of evidence.
Sir,
or
that is a different aspect. Oral evidence, is there any exemption for oral evidence?
My lords, there is no hard and fast rule.
No,
What it
there
says
can't
is,
be, sir. There can't be.
My lords, it says adequacy of evidence or
Correct.
reliability
What
of
type
evidence.
of adequacy of evidence? What type of evidence?
My lords, now,
Documentary as well as oral evidence. Now you are rightly or wrongly you are relying on 2-3 documents. That must be supported by evidence, the corroboration. Corroboration by whom?
no,
author of the document.
That is as per the Evidence Act. What my lords is saying is absolutely correct.
Ah.
Lords, I don't disagree with that, lords. That is absolutely correct. But here that Evidence Act is not fully applicable.
Ah.
Here it is not necessary.
Yes, sir.
Lords, that is what I am trying to say.
Then what is the object of citing list of witnesses?
My lords, because if there are sometimes, my lords, there are some matters where the allegations are made on oral basis, like on complaint, then, my lords, oral evidence is essential.
Yes,
but
here also it's a complaint.
my lords, if it is borne out from the records, if a charge is an official is charged on the basis of a record, then, my lords, record is the evidence, and for that there is no denial on that. And if there is no denial on that, my lords, then, my lords, it has to be on that basis. Oral evidence is not required.
So he has admitted the charge.
Beg pardon, lords?
He has admitted the charge.
He said yes. He admits that yes, show cause was given.
Show us one word
Yes.
that he has admitted.
No. The charge speaks about the show cause. Now he does not deny that the show cause was not given, or that the documents which has been referred into the charge was not there. He is not denying the fact.
But has he denied the allegation or not?
Yes.
He has denied the allegation.
He has said that subsequently that was withdrawn. That is all he has said. Now, once you say that it was withdrawn, that means he accepts that letter was there.
No, he
Where
says
was
that
the
it was
requirement of oral
He
evidence?
says that it was
So,
modified.
oral,
He says that it was modified, and instead of a particular college,
true,
he was
my
asked
lords.
to visit all the
Now
colleges.
we have to see.
Therefore, charge number 2 must go.
My lords,
Why it was partly proved?
Therefore, we have to see as to on what basis partly proved finding has been given by the inquiry officer.
Now read the inquiring officer's finding.
That is what I thought I should complete this, my lord, before.
This is not relevant. That oral evidence is required to be ignored.
I was only reading to the extent, my lords.
Sir,
That-
oral evidence is not warranted according to you. According to us, oral evidence is required for the simple reason that statutory rules provides that while framing article of charges, you are required to furnish the statement of imputation, list of documents, list of witnesses. Then what is the object of issuance of list of witnesses?
Now, this, first of all, my lords, this charge sheet has been issued under Rule 1930.
Yes.
Now, there, in that rule, there is no such provision.
All right.
Now, nevertheless,
Rightly or wrongly, you are relying on some documents.
now, my lords, that document list has been given along with the charge sheet. That your lordships will see, that is enclosed with the charge sheet. साक्ष्य की तालिका दी गई है, तो साक्ष्य की तालिका दी गई, इसमें कोई dispute नहीं है. There is no dispute on that. So, अपना ही आप ही का annexure है. Annexure 4 में भी see. That is the department. My lords may see page 49. 4 अनुलग्नक प्रपत्र क में गठित आरोप पत्र एवं साक्ष्यों की छाया प्रति के साथ. That has been served on him. And my lords, it is not a case of, my lords, dismissal or any major penalty, where a penalty is only
Sir,
censored.
irrespective of whether minor penalty or major penalty,
True, my lords.
you are required to
I quite
provide
agree.
a principle of natural justice.
Yes, there, my lords, is, and that question has been answered. My lord, there is no objection on behalf of the petitioner as well that any principle of natural justice has been breached. There is no objection on that.
On the contrary, he says that the department had not produced any witness to prove the charge sheet against the petitioner, nor any document were got exhibited to establish any of the charges against him.
My lords, the
Contrary to
documents
the
were there
submission
along
made
with
by-
the charge. The documents were there along with the charge. No oral evidence was led, my lords, that's true. I mean, there is no dispute on that. And the need was not there because it was all based on, my lords, the file records. And record was not denied even in his written statement. He has only answered whether the charges are level against him is proved or not proved, or whether he accepts or does not accept. Now, my lords, the finding which has been recorded here with respect to is annexure 9 in the inquiry report. is a detailed inquiry report, my lords.
Page 42 onwards.
My lords, it's a detailed inquiry report that starts from page 83 on 82 onwards, my lords. 79 minutes, 79, 82 onwards. With respect to किसका निष्कर्ष है, पर सबका अलग अलग निष्कर्ष है. Now, so far as charge number 2 is concerned, my lords, that has been dealt with. हाँ? कितना है? 84 पे है.
Is it on page number 84, page 20, para 21? Page 80.
Same.
How it is partly proved.
Now, my lords, at least 5-6
Page-
pages he has dealt with it, this chart. And here,
Page 84, para 21, regarding Arop Sankhya 2.
my lords, yes,
Read that.
it's a long 5 pages, my lord, finding.
Huh?
The finding is in 5 pages.
You have lost the file.
No, 5 pages the finding is running, my lords.
Is missing.
With regard to charge number
Not
2.
take a file from the respondent counsel.
Now, my lords, I am submitting, my lord. सुनवाई के दौरान, may I submit? Read, my lords, that the relevant part is from page 75. सुनवाई के दौरान आरोपित ने ऊपर वर्णित 3 प्रतिनियुक्ति संबंधी कार्यालय आदेशों का पुनः वर्णन किया है, जिसकी हियरिंग जिसकी पुनरावृत्ति नहीं की जा रही है. उनका कथन था कि ज्ञापांक इतना उन्हें दिनांक 28/3/93 को मिला, जो होना था वह पहले ही हो चुका था. इस ज्ञापांक में कहा गया है कि दिनांक 27/3/93 से परीक्षा होने वाली है. केवल नियुक्ति स्थल में फेरबदल किया गया है.
Which page?
पेज में लॉर्ड 75 कितना 86 ना. सुनवाई पैरा 28 पे है हुजूर, पेज 86, आरोप संख्या 2 की संदर्भ में सुनवाई है. सुनवाई के दौरान आरोपित ने ऊपर वर्णित 3 प्रतिनियुक्ति संबंधी कार्यालय आदेशों का पुनः वर्णन किया है, जिसकी पुनरावृत्ति नहीं की जा रही. उनका कथन था कि ज्ञापांक 27/3/93 उन्हें दिनांक 28/3/93 को मिला, जो होना था वह पहले ही हो चुका था. इस ज्ञापांक में कहा गया है कि दिनांक 27/3/93 से परीक्षा होने वाली है, केवल नियुक्ति स्थल में फेरबदल किया गया है. आरोपित के भूपेश गुप्त कॉलेज के बजाय उड़न दस्ता में दे दिया गया था, इसलिए भूपेश गुप्त कॉलेज में इनकी प्रतिनियुक्ति की कोई प्रासंगिकता नहीं रह गई थी. फिर भी पुराने आदेश के अनुपालन में वे दिनांक 27/3/93 को भूपेश गुप्त कॉलेज गए थे. कॉलेज बंद था, परीक्षा स्थल में ताला लगा हुआ था, कार्यालय मात्र खुला हुआ था. वहीं उन्हें पता चला कि परीक्षा स्थगित हो चुकी है, बैंक में हड़ताल हो गई है, जिसके चलते प्रश्न पत्र नहीं निकाल पाया है. वे लौटकर चांद चले गए. वहां उन्हें चकबंदी पदाधिकारी का काम करना था. आरोपित ने कहा कि दिनांक 28/3/93 को जब उन्हें अनुमंडल पदाधिकारी पुनरीक्षित आदेश मिला जिसकी प्रासंगिकता नहीं रह गई थी, तब भी उन्होंने अनुमंडल पदाधिकारी से विमर्श किया। बीच में रामनवमी की छुट्टी आ गई थी। अनुमंडलाधिकारी से मालूम हुआ कि परीक्षा अब दिनांक 6/4/93 से होने वाली है और उसका आदेश अलग से निकलने वाला है। इस तरह वे इस प्रसंग को समाप्त समझ लिए। अपने कथन को सत्यता स्वरूप अनुमंडल पदाधिकारी के ही ज्ञापांक दिनांक 3/4/93 को उद्धृत करते हैं और कहते हैं कि इसी से प्रमाणित होता है कि परीक्षा स्थगित हुई एवं इसका कारण था। किसी भी हालत में दिनांक 27/3/93 को भूपेश गुप्त कॉलेज में उन्हें उपस्थित रहने की अपेक्षा करने का औचित्य नहीं था, चूंकि अनुमंडलाधिकारी पहले ही उनका प्रतिनियुक्ति स्थल बदल करके उड़नदस्ता कर चुके थे। विश्लेषण: इस मामले में आरोपित के विरुद्ध यह बात धारित हो गई है कि 27/3/93 को वो अपने प्रतिनियुक्ति स्थल पर नहीं गए, जो भूपेश गुप्ता कॉलेज भभुआ था। आरोपित का कहना है कि वे गए थे। इस बात का निश्चित सफल निर्णय होना उपलब्ध कागजात से संभव नहीं है। आरोपित द्वारा दिखाए गए कागजात से अवश्य प्रतीत होता है कि यदि वे नहीं भी गए थे तो उसके विधि व्यवस्था संबंधी किसी ड्यूटी की अवहेलना नहीं हुई है। परीक्षा स्थगित होने की सूचना सामान्यतया उनके स्रोतों से पहुंच जाती है। केवल दंडाधिकारियों एवं परीक्षा केंद्र में प्रतिनियुक्त कर्मचारी की ही बात नहीं है, लाखों छात्र भी इसमें शामिल होते हैं। इसलिए किसी न किसी प्रकार से प्रभावकारी संचार माध्यम से सक्षम एजेंसी यह प्रचार कर देती है कि अमुक तिथि को होने वाली परीक्षा अब स्थगित हो गई है और इससे संबंधित अन्य कोई सूचना हो। जहां तक अनुमंडलाधिकारी की बात सही है कि दिनांक 27/3/93 को यदि आरोपित भूपेश गुप्ता कॉलेज में नहीं गए तो यह ड्यूटी की अवहेलना है। उनकी ड्यूटी बदल गई। यद्यपि वह अनुमंडलाधिकारी ने दिनांक 27/3/93 को निर्गत आदेश से ही सूचना दी थी, मगर आरोपित का स्वयं अपना बचाव है कि संशोधित आदेश उन्हें 28/3/93 को मिला। यह संभव है कि दिनांक 27/3/93 को जब आरोपित को प्रतिनियुक्त बदलने की जानकारी नहीं थी तो उन्हें कॉलेज के केंद्र पर खोजा जा सकता था। यह अपेक्षा उन्हें हो सकती थी कि परीक्षा नहीं होने की जो स्थिति है इससे अनुमंडलाधिकारी को भी अवगत करा देते, चाहे स्वयं मिलकर या पत्र के माध्यम से। अतएव आरोपित के अपने ही स्पष्टीकरण से यह दायित्व तो उन पर ही जाता है कि दिनांक 27/3/93 को उन्हें अनुमंडलाधिकारी को कोई न कोई सूचना देनी चाहिए थी। उनके न जाने से कोई हानि हुई या नहीं, यह बात अलग है और कर्तव्य के पालन में सीधे संबंधित नहीं है। आरोपित का कहना है कि वे अनुमंडलाधिकारी को स्पष्टीकरण पत्र मिलने के बाद उनसे मिलकर वस्तु स्थिति बताए। यह भी एक मौखिक वार्तालाप है। इसके संबंध में प्रमाण के अभाव में कुछ कहना मुश्किल है कि इसमें कितनी सत्यता है। आरोपित स्पष्टीकरण का टिप्पणी करते हुए समाहर्ता ने यह ठीक ही कहा है कि अपने स्पष्टीकरण में आरोपित यह कहीं नहीं कह रहे हैं कि उक्त तिथि को वे कहाँ थे और उस तिथि को उनके द्वारा किस किस सरकारी कार्यों का निष्पादन किया गया है। इस प्रकार से यह उन्होंने प्रमाणित माना है कि स्पष्टीकरण का पत्र उन्हें मिला, लेकिन अपनी स्वेच्छाचारिता के कारण उन्होंने पत्र का कोई जवाब नहीं दिया। इस प्रकरण में आरोपित ने 3 स्पष्टीकरण दिया है। एक पत्रांक 22/4/2001 जो कार्मिक एवं प्रशासनिक सुधार विभाग को संबोधित है। इसमें उन्होंने कहा है कि वे प्रतिनियुक्ति स्थल पर उपस्थित होकर विधि व्यवस्था का संचालन किए थे। अनुमंडलाधिकारी का स्पष्टीकरण पत्र उन्हें प्राप्त नहीं हुआ है। इस अवधि में आरोपित उड़नदस्ता दंडाधिकारी के रूप में भूपेश गुप्ता महाविद्यालय में प्रतिनियुक्त थे। उस अवधि का अभिलेख उस कॉलेज एवं स्टेट बैंक भभुआ के मुख्य शाखा में देखा जा सकता है। उन्होंने प्रश्न पत्रों को बैंक से निकाले जाने और टिप्पणी करने के पैकेट बनाए जाने के कार्यों को अपनी उपस्थिति में संपन्न कराया था। इस पत्र में किस तिथि को यह सब कार्य किया गया उल्लेख नहीं किया गया है। यदि अनुमंडल पदाधिकारी का पत्र उन्हें प्राप्त होता तो वे अपना स्पष्टीकरण जरूर देते। दूसरा स्पष्टीकरण बचाव बयान के रूप में दिनांक 31/12/2002 को दिया गया है। इसमें उन्होंने पूर्व के स्पष्टीकरण 22/4/2002 को स्वीकार करने का अनुरोध किया है। उनका मुख्य कथन है कि अनुमंडलाधिकारी ने अपने आदेश को स्वयं ही परिवर्तित कर दिया था और उसका भी अनुपालन उन्होंने निष्ठापूर्वक किया था। इसमें भी उन्होंने दिनांक 27/3/93 को ये कहे थे कि वहाँ गए थे और कुछ भी नहीं लिखा है। तीसरा स्पष्टीकरण दिनांक 24/8/2004 को समाहर्ता को मंतव्य जब आ गया तो उसको देखने के बाद दिया है। इस बार वे कहते हैं कि दिनांक 27/3/93 के परीक्षा के स्थगित होने की सूचना आरोपित सहित जिला एवं अनुमंडल प्रशासन को दिनांक 26/3/93 को ही प्राप्त हो चुकी थी। अतः अनुमंडलाधिकारी बबुआ के आदेश दिनांक 24/3/93 के अनुपालन का प्रश्न ही नहीं रह गया था। इसके बाद जो आदेश ज्ञापन 4/3/93 के जारी हुआ उसका इन्होंने अनुपालन किया है। जिला पदाधिकारी के मंतव्य को उन्होंने भ्रामक बताया, कहा है कि उन्हें मूल पदस्थापन चकबंदी पदाधिकारी चांद के अलावा 1 दर्जन पदों का प्रभार दे दिया गया था, इसलिए उन्हें निरंतर भागदौड़ में रहना पड़ता था। यह प्रश्न भी उन्होंने उठाया। यदि वे इस लापरवाह एवं कर्तव्यहीन व्यक्ति थे तो उन्हें इतने सारे पदों का प्रभार दिया ही क्यों गया। आरोपित ने केवल सुनवाई के दौरान यह बात कही कि जब कॉलेज गए और वहां ताला लटका पाया तो कार्यालय के जानकारी लेकर चांद चले गए, वहां उन्हें कुछ काम करना था। इस तरह से 3 लिखित स्पष्टीकरण और मौखिक सुनवाई में कही गई बातों में अंतर हो जाता है। समाहर्ता द्वारा उठाए गए ये प्रश्न उचित है कि आरोपित केवल आदेश अनुपालन की आवश्यकता न होने की बात को छोड़कर वे वास्तव में कहाँ वे लिखित रूप में नहीं बता रहे हैं, कहाँ थे लिखित रूप में नहीं बता रहे हैं। उस दिन किए गए किसी कार्य का कोई ब्यौरा भी नहीं समर्पित किए हैं। तीसरा स्पष्टीकरण देकर आरोपित ने स्थिति को और भी उलझा दिया है। उनका कहना है कि दिनांक 26/3/93 को ही अनुमंडल प्रशासन तात्पर्य अनुमंडलाधिकारी से निश्चित रूप से होता है के परीक्षा स्थगित होने की सूचना हो गई थी। अगर उनके वक्तव्य को मान लिया जाए तो दिनांक 27/3/93 को अनुमंडलाधिकारी द्वारा हस्ताक्षरित आदेश बिल्कुल ही गलत और प्रसंगविहीन हो जाता है। परीक्षा स्थगित होने की जानकारी मिलने के बावजूद भी दिनांक 27/3/93 को इस तरह का आदेश अनुमंडलाधिकारी शायद ही निकालेंगे। यह हो सकता है कि इस तरह की अनौपचारिक सूचना कुछ देर से आए। इस भरोसे आरोपित अपनी अनुपस्थिति को जायज नहीं ठहरा सकते हैं और उससे भी कम मांगे गए स्पष्टीकरण का उत्तर न देने का औचित्य बनेगा। इसी तरह के सभी प्रसंगों को देखने से यह मालूम होता है कि आरोपित ने दिनांक 27/3/93 को अपनी प्रतिनियुक्ति के आदेश का अनुपालन नहीं किया। इसकी वजह उनके मुख्यालय से बाहर रहना था या नहीं यह प्रमाणित नहीं हो सकता है। इससे कोई नुकसान भी नहीं हुआ क्योंकि परीक्षा स्थगित हो चुकी थी, लेकिन आरोपित को स्पष्टीकरण का उत्तर देना चाहिए था। उनके द्वारा दिए गए विभिन्न स्पष्टीकरण विरोधाभासी हैं। महत्वपूर्ण बिंदु सुनवाई के ही दौरान किए गए वक्तव्य का उतना महत्व नहीं है। यदि वे लिखित स्पष्टीकरण में नहीं दिए हों, फलतः यह आरोप इस अंश तक प्रमाणित है कि अनुमंडलाधिकारी द्वारा मांगे गए स्पष्टीकरण का उन्होंने उत्तर नहीं देकर स्वेच्छाचारिता बरती है। इसलिए आरोप संख्या 2 अंश तक प्रमाणित।
No, by using only one word,
Yes.
consider. Then each of the contention is required to be dealt with. Where is his reply to the show cause? What are the contention taken by him?
Where is his reply to the second show cause notice?
Beg pardon?
Where is his reply to the second show cause notice?
Yes, second show cause notice. He had replied on 2/8/2006. Document है. Annexure 10 is the second show cause, my lords, in the writ. At page Annexure 10 है. 121. That is the second show cause notice. And my lords, the next page, page 39 is his explanation.
All right, now you, what are the contention taken by him in the reply to the second show cause notice has been considered by the disciplinary authority. In the show cause notice, he has raised a few points.
My lords,
For example, 1 to 5, that has been considered by disciplinary authority on page 39 in annexure 1.
annexure 1, my lords.
Annexure 1. Show me
Annex-
at least,
Annexure is this is the order of the reviewing authority.
no, this is the order of a disciplinary authority 6/2/2008.
That is annexure 2.
2 is appellate authority's order.
No.
2 is the original order.
Huh?
Annexure 2 is
Punishment order is
punishment
annexure
order.
2.
Annexure 2 is punishment order.
Page 41.
Page 41. In
Where,
that,
where is the consideration of petitioner's reply?
not a single word.
My lords, it says para 2 is the consideration part, para 1 deals with the charge, 2 is the consideration part.
Correct, show me by point wise. He has raised about, his reply running about 5 pages. Show me 1 or 2 contentions which have been dealt by the disciplinary authority, so as to come to the conclusion that the disciplinary authority has applied his mind.
Now, my lords, he has dealt with at para 2. May I
Correct,
read
only
it?
consider representation.
Only one word.
That is not the consideration. What is meant by consideration?
My lords, it says.
Now take the disciplinary authorities, sorry, rule, rule 17.
My lords, that is not applicable here in this case. It was this proceeding was not on this.
That is applicable for the reasons I will show you. Read rule 32 of CCA rules 2005. You have a CCA rules 2005.
Beg pardon?
You have a rules 2005.
Yes.
Read rule 32.
No, that I have seen.
Rule
That I have
32
seen.
is repealed.
No, 2000.
Sir, the penalty is after 2005.
But
Penalty is after 2005.
But the proceeding was initiated under.
All right, sir. Proceedings all right.
1930.
As on the date of penalty, which rule was existing? As on the date of imposition of penalty.
My lords, it is a settled law that the proceeding which is initiated under a particular rule or law.
That is the reason I am
will
asking.
be applicable.
That is the reason I am asking you.
On the
Please
date of penalty will not.
Sir, that is the
change
reason.
rule.
Please, I am asking you to read rule 32 of CCA rules.
30.
Repealing provision.
32 of the CCA rules 2005.
Yes, sir. Repealing and savings.
32 is repeal and savings.
Read sub rule 5.
My lords, notwithstanding contained in these rules, any departmental proceedings initiated under the rules repealed shall continue under those rules, including the appeal preferred against any punishment imposed, as if those rules were still in existence. Will continue under those rules. Under those rules, old
Yeah.
rules.
Yes. Now in
My
the
lord.
old rules, you point out which is the relevant appeal rule.
That is what, my lords, I am submitting. That 17.2 is
Correct,
will
sir.
not apply.
From that only one can draw inference how disciplinary authority and appellate authority are required to function.
My lords, my lords, it says that if not
Sir, if the departmental
any
inquiry-
departmental proceeding initiated under the rules repealed, that is 1930, shall
1930.
continue under those rules.
Yes. Now from the old rules, you point out disciplinary authority how he has required to act.
Is 1930 rules, there is no such provision.
There is no provision.
My lord,
Then
thank you, sir.
under which provision of you are going to impose penalty?
Rule 55, Rule 55 and 40, read with my lords, penalty is dealt with in Rule 40, 49. Penalty is under 49 and Rule 55 is the the provision under which the proceeding is to be initiated, the departmental proceeding for major penalty. But Malas 49, 1 is censure, 2 is withholding of increment, which has been imposed. 55 is the provision under which the inquiry has been initiated.
In the old rules, there is no provision for issuance of second show cause notice. Then why did you issue a second show cause notice?
My lords, it was since an inquiry report was there, therefore, my lords, additional.
Correct, sir. Under Rule 55, there is no provision for issuance of furnishing copy of the inquiry report and issuance of show cause notice. And there is not even a provision for appointment of inquiring authority. But still,
1930.
but still, you appointed.
That is better. You were given ample.
No, better means
even more.
you stick to one thing.
No. My lords may see the proceeding which has been initiated, the resolution of the government. My lords may come to annexure.
Correct. Which
4.
is the provision of law.
My lords may come to annexure 4. That is the resolution of the government by which the proceeding was initiated.
Sir, 2002 charge memo.
That is, my lords, संकल्प. That is the resolution. नियमावली के नियम जांच के उनके विरुद्ध असैनिक संवर्ग सच नियमावली नियम 55 के विहित नीति के विभागीय कार्रवाई चलाई
Sir,
जाए.
under Rule 55, there is no provision for appointment of inquiring officer, presenting officer.
Yes.
But still, for the purpose of
better principle of natural justice compliance.
all right, we'll take into consideration whims and fancies of the disciplinary authority. He can choose this way or that way.
My lord, the government resolution is there to initiate the proceeding under 55.
Yes.
So he has to do it.
Correct.
My lords, but suppose even if suppose additional opportunity is
Sir,
being given, that will not negate.
All right, but you have to stick to one rule, no?
No. Even
Sir, after 2005, you have followed 2005 rules.
Yes.
How can you follow? In terms of Rule 32 of Sub-Rule 5 of Rule 32 of CCA rules, you are required to follow old rules.
Yes.
So from the
Where
issuance of-
there is that is not a question of following this rule or that rule. That is a question of giving additional opportunity. That additional opportunity was given, then that will not negate the order as bad.
So we-
because why additional opportunity was given?
All right, sir. If rule sub rule 5 of rule
If
32,
the rule does not require,
if sub rule 5 of rule 32 is interpreted,
Milords.
then you are required to follow only old rules.
True, my lords.
Therefore,
Even
you-
now, even while following the old rule, my lords, I put a question to myself that if additional opportunity is given, which is not supposed to be required for the second so-called notice, if it is done, can that be interpreted as a breach and therefore the entire proceeding is bad?
Because
that
it
is
wa-
an additional opportunity.
Because it violates article rule 32 sub rule 5. Because rule 5 says you have to follow old rules.
That is not for the purposes of following a particular rule. That is an additional opportunity. That does not
Where have
mean.
you stated that in order to give additional opportunity, we
that
are
is-
issuing show cause notice and we are ignoring old rules? Where have you stated? Where have you stated in any of the document in order to give
No.
in order
That
to
was
give
only a
ample
sub-
opportunity?
That was only by way of a submission to my
Submission,
lord.
yes, yes.
That was only by way of a submission to my lord. That even if my lords, the old rule does not provide that. The submission is that merely for the reason that the authority, for whatever reasons, my lords, maybe at the time when he is passing an order,
And
there are so many.
and so also show me from the old rule where is the appeal?
My lords,
Appeal provision from the old rules. Appeal against the penalty order.
there is no appeal filed. He has filed a review.
Review.
Yes.
No, Annexure 1 says appeal.
Annexure 1 is relating to appeal.
He had not filed any appeal.
Rule
The
56.
order.
All right, show me
Annexure
where
1
is
is.
where is the review or revision under the old rules?
No, review is. My lords, review.
Sir, you stick to one thing. Has he filed a review or revision?
I filed appeal in terms of rule of
My lords, the Annexure 1 is the order.
And the learned single judge has also taken note of that a cryptic order has been filed in the appeal.
My lords.
The learned single judge has also taken note of this appeal, appellate order,
Yes.
authority's order.
A shorter.
It is very cryptic. Only
Just
because,
for the reason.
Only because it was approved by the cabinet, hence it was again placed with the cabinet and cabinet
My
rejected
lords,
the appeal.
so far as I understand,
Without
my
assigning
lords,
any reason.
in
We agree with
in
the
so
order
many
of the original
departmental
authority.
proceeding cases, what I find is that the disciplinary authorities do not give detailed reasons in case the inquiry findings are given in ample detail. If the finding of the inquiry officer in great detail, they don't go on the detailed findings.
They
They adopt and accept it.
Disciplinary authority need not. But appellate authority?
Beg pardon?
Appellate authority? There is a provision.
Appellate authority has gone through the inquiry report.
Now you say, now you stick to your stand whether petitioner has filed appeal, revision or review. Which one?
कहाँ है रिवीजन का जी? एप्लीकेशन कहाँ है?
Application नहीं लगा है.
Well, he has to show the application.
यहाँ लिखा हुआ है अपील अभ्यावेदन समर्पित किया.
ऑर्डर में ही है।
Order में.
And rejection of appeal.
And rejection of one line.
No. Whether rejected appeal or
Yes,
appeal.
yes. Appeal अभ्यावेदन.
Then how can you say review revision?
And the reason assigned is because
Point out.
he is irritating. Sir, last 4 lines of the Annexure 1. Last 4 lines, column 2.
तहत संचालित
And then the final order.
संचालन।
अतः मंत्री परिषद के निर्णय के आलोक में श्री राम द्वारा समर्पित अपील अभ्यावेदन को अस्वीकृत किया गया।
अभ्यावेदन है। उपर्युक्त दंड के विरुद्ध श्री वेतनाथ ने सरकारी सेवक वर्गीकरण, नाउ ही हैज फाइल्ड इट इन 2005 rules. Under the 2005 rules, he has filed के नियम 32
He should have rejected.
आप
के तहत
No, he should have rejected at
अभ्यावेदन
threshold,
समर्पित किया
stating
श्री
that
राम
the
द्वारा समर्पित।
2005 rule is not applicable.
it has been rejected by saying that there is nothing new said.
So
All
they are
has
not
been
aware
dealt.
which provision of law is applicable to the present case by the disciplinary
No,
authority.
I am fully aware. My lords, it has been dealt with.
Huh?
My lords may see in this annexure 1.
Now from the, that's what Mr. Council, I am
in the
asking
middle.
you, show me where is the rule, in the old rules, there is appeal provision.
My lords may see perhaps uh,
Rule 56.
56.
Huh?
But under Rule 56, he has not preferred an appeal.
All right, have
He
you,
has preferred
have
an
you
appeal under
considered, have you considered under Rule 56? No, you have considered under Rule 2005.
No, he has filed it under 202.
All right, sir, assuming that he has quoted wrong provision,
You accepted.
True.
disciplinary authority, appellate authority, is it not required to examine which rule is applicable, whether Rule 56 or Rule 27 of 2005?
It can be said, though he had preferred it in 2005, but it can be taken as an appeal under 56, though not stated.
Depending upon the
But
convenience, depending upon the convenience of the state.
No, my lords, it has been clearly noted.
No, we should say that it is deemed that his appeal is under 56 and it has been considered
My
under
lords,
Rule
seventh-
57.
My lords, 12th line specifically recognizes that the proceeding was under 1930 rules. It is not that they were not aware. And
At the same time, you are not aware, you being the disciplinary authority and appellate authority,
जिला-
which is the relevant rule,
आरोपों के
and you are
लिए
blaming the petitioner.
My lords, this has been found out in the order itself.
Yes, the petitioner stand dismissed, brother will write judgment.
My lords. Only one more thing, my lords. Two judgments, one judgment.
Yes,
I had-
2021.
2021 and my lords, two more judgments, my lords, that I had
That the
listed.
oral evidence is not warranted.
Yes. Now, my lords, I have given the list also. That is,
Give the relevant paragraph number against that judgment.
my lords. The second one is, my lords, 2009 volume 8 SCC page 310, State of Uttar Pradesh and another versus Manmohan Nath Sinha.
Para?
Para is 15 and 16. Then the third is, my lords, 1991 volume 2 SCC page 716. Maharashtra State Board of Secondary and Higher Secondary Education versus K.S. Gandhi.
Paragraph.
Paragraph, my lords, is para 21, 20, 21 and 22. And my lords, paragraph 38 and 40.
एक स्लिप दे दीजिए ना कोर्ट मास्टर साहब.
हम सब लिख के दे
स्लिप दे.
सब लिख के दे
एक चीज
Yes, what do you want?
हाँ, इनका बहस था उनकी ये माइनर पेनल्टी है, माइनर इट इज ए मेजर पेनल्टी लॉस. स्टॉपेज ऑफ इंक्रीमेंट विद कम्युलेटिव इफेक्ट लॉस इज मेजर पेनल्टी.
With cumulative effect.
Loss, major penalty. It comes from 1991.
No, the order penalty is with cumulative effect.
Loss.
Yes.
It is major penalty. Several
Major
judgments are loss. Even loss of Rule 55 itself says कि examination of witness, cross examination, everything is there.
if so desired.
Rule 2005 has been introduced, come into picture. In Rule 42, sub-rule 5, sub-rule 5 of Rule 42 provides for continuation of the inquiry proceedings in the old rules. Whereas the disciplinary authority issued a show cause notice and imposed a penalty under the new rules. Similarly, appeal was entertained under the new rules. There is a non-application of minor by the disciplinary and appellate authority. And the appellate authority order is cryptic. It is not in terms of reason. It is not a reason